After more than 2 months of squirming, side-shifting, bubbling, and suffering, the camel of the 26th constitutional amendment has finally crouched in favor of the government coalition. Indeed, the ground reality is that the 26th Amendment has come to the fore of the Constitution. All the changes made through this amendment have become part of the Constitution of Pakistan. The rank and place of these changes is now the same as that of the clauses in the 1973 Constitution. Parliament has exercised this prerogative under Article 239(6) of the Constitution, which states, "For the removal of doubt, it is hereby declared that there is no limitation whatsoever on the power of Majlis-e-Shura Parliament to amend any of the provisions of the Constitution. For the removal of doubt, it is hereby declared that there is no restriction whatsoever on the power of Majlis-e-Shura Parliament to amend any of the provisions of the Constitution. Parliament has the power to make any kind of change in the existing articles in the Constitution. The only condition is that it gets the support of two-thirds majority of the total members in both the houses of the parliament. The judiciary, which considers itself to be above all constitutional restrictions and has unlimited powers, with which the amendments approved by the parliament are ruthlessly put on the practice board of the operation theatre, is not allowed by the constitution, would give justice if Iftikhar Chaudhary had brought the 18th Amendment of to the docket to completely free the power of appointment of judges from the role of Parliament and to take it into its own hands, even though Article 239(5) of the Constitution states that no amendment of the Constitution shall be called in question in any court on any ground whatsoever. No questions can no questions can be raised No question can be raised in any court about any amendment in the Constitution on any grounds whatsoever, but this question is raised and veiled. The constitutional experts keep shouting that the Constitution does not allow this, but the judges open the locked door of the Constitution with the talismanic key of interpretation, and lay the groundwork of arbitrariness. The judiciary, following the same behavior with the 18th Amendment, forced the legislature to limit its power through the 19th Amendment and to entrust the judiciary with the discretionary power to appoint judges. The 25th constitutional amendment to merge FATA with Khyber Pakhtunkhwa was passed in May 2018. Jamiat-ul-Ulama Islam had opposed it then, but Tehreek-e-Insaf had voted in support of it with great enthusiasm. For the 25th Amendment, not so much money had to be paid. Now there was a commotion in the entire country. There was no attraction for the media and any other topic. A circle of rumors, conjectures, guesses, and speculation ensued. The situation was swinging between belief and uncertainty. During all this practice, Maulana Fazlur Rahman Astana Alia remained the abode of Khawas. The founder of Tehreek-e-Insaf and his devotees did not say anything about Maulana, which did not abuse. How did they not throw splashes on their domes? But Maulana explained with his open heart and broad-mindedness that what is politics? What are the requirements of democratic values and ethics? What is understanding and understanding? How are the tangled knots of political affairs untangled? And how do you keep your doors open to even the fiercest opponents? Has PDI gained anything from this political lesson of Hazrat? Leaders of the parliamentary parties in the Senate were later included in the special committee formed